Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from the Informer and Routledge organisation, which is part of Taylor and Francis. And the book we're looking at is on maritime law. It's shipbuilding, sale and finance, a fascinating area and an important area because of the amount of money involved. This book is actually part of the Maritime and Transport Law Library, and it's been edited by two people, Barris Sawyer and Andrew Teppenborn. Now, the title we've given our written review, which is on the web and in the journals, is this. Because having a ship constructed is not like ordering a new Ford Focus, ship practitioners need this book. We will explain more in a moment. We review these works on the basis that they're very good books of a very high quality and of great value to us as practitioners, commentators and researchers in our own area. This is the book here, nice blue cover. It's a hardback. There's the spine. You can see it's part of the Maritime and Transport Law Library, which is set there. And then there's nothing on the back. If we go into the book itself, it runs to nearly 500 pages. And the index is on page numbering, not paragraph numbering, which you can see there. Then there are quite a large number of appendices. That's appendix 7. Let's go to the front of the book again. You can see the actual front page is there. But then you've got, that is actually the law library itself that has been produced by Informer over what has been a long period of time. We have reviewed these books before, some of them, and they are, of course, an important contribution to this very substantive area. This again says it's first published in 2016. I've actually been recording this towards the end of 2015. There's the table of contents, and you can see how it's structured. You've got a number of different chapters, and you've got the names of the people. Because this is edited by two individuals, you've got a number of people who are contributors throughout. You can see the chapters as we run through them there. There are a total of 15 chapters. Then there are a number of appendices, 8 in fact, in total there. Then you've got the biographies of all the individual people. Very experienced people. I can't name them all because of the numbers, but you will probably know a number of people yourself who contributed to this. Experienced people with a great fund of knowledge, and we really can't do our jobs properly without having this sort of document. Now, Anthony Clark, Lord Clark of Stone-cum-Ebony, has written a very useful foreword. It's dated April 2015. He says, "I am ashamed to say that until I went to the opening of the colloquium, the Institute of International Shipping and Trade Law at Swansea University, September 2014, I knew nothing either about the Institute or the colloquium." And he then goes on to say he now does. So thank you, Anthony. There's a preface there. And then after that, you've got the table of cases. And then after that, you have a little bit of legislation. Just a very small amount. Then we get into the work itself. Part 1, legal issues relating to shipbuilding. An important area, especially over the centuries, and it's useful to have something like this for today. Now let's just go into the book itself. You will see there's paragraph numbering at the sides, and there's some footnoting. So you do have a lot of justification of assertions made, and you have a huge amount of what effectively is the law, if you like, in relation to this particular area. You do have, I think, in the appendices some very useful information. Let me just pick this one. Bearing in mind the Chinese delegation is visiting this country while I record this. Appendix 2, China Maritime Arbitration. Again, very relevant just at the moment. That's the Shanghai form, which is very substantial, in fact. Then we get on to Sale Form 2012 there, and so forth. So there is a huge amount of detail in this book. So I say it's running to about 500 odd pages. Quite a heavy book as well, actually, quite surprisingly heavy. Very nice paper used as well, which I'm pleased to mention. So the pages won't hopefully rip too much. As I say, you can see from it that it's actually quite a heavy book, and I'm just going to get it to settle down a bit there. There we are. Now, what do we say about the book? Well, we say this. One of the recently published additions to Informer's Maritime and Transport Law Library, this book presents the latest thinking and research in, as the title indicates, shipbuilding, sale and finance, very important areas. It's 500 or so pages, contains 15 chapters, each a mini thesis, so to speak, on specific topics within this subject area. To say that the co-editors plus the 13 contributors are leading experts in this field is no doubt an understatement, as all of them hail from the leading specialist chambers and law firms, as well as the top academic institutions, mostly based in the United Kingdom. And each chapter presents with clarity and illuminating detail the salient points the shipping practitioner needs to know, with an approach that is both plain speaking and practical. And the book itself is not as difficult as you would at once think it is to read. It's actually eminently readable and well presented. The book, the volume itself, this one, presents the work of the 10th IISTL colloquium, which I mentioned before, that being the Institute of International Shipping and Trade Law. Now, there are many of these organisations around, and it's quite understandable if you're not quite as familiar as you might be with them. But however, this is an important colloquium that took place. It was founded in the year 2000 at the Swansea Law School, and the Institute promotes the academic study and development of maritime and commercial law and organises regular colloquia in the area. And the co-editors, Andrew Tettenborn and Barris Sawyer, are themselves at Swansea Law School, as are some of the other contributors. Now, writing in the foreword, Lord Clarke, who I mentioned, who's a Justice of the Supreme Court, has described the book as a tour de force. 6 of the chapters are on legal issues relating to shipbuilding, followed on the remaining chapters covering ship sale contracts and practice. Again, I think that'll be quite helpful to both firms and counsel. The book, says Clarke, is a most impressive body of work on a whole area of law, and he refers further to the formidable amount of research it contains, and he notes it has no less than 1,165 footnotes. I wonder if that's a record for the size of a book. I don't think so, but there we are. Actually, the contents of the book are grouped into 3 parts. The first section covers legal issues relating to shipbuilding and the application of standard form contracts to general contractual principles. And the other relevant topics, notably risks, insurance and refund guarantees, are of course also covered. Part 2 then goes on to focus on ship sale contracts and practice. It narrows it a bit, and it includes a chapter on the battle of the sale forms and another on the as-is provisions in ship sale and purchase contracts. Again, a technical area and a complicated area, but I think it's well explained. The final chapter in this section, which covers the practicalities of ship sales in the current market, summarises both the practical aspects and the pitfalls that a practitioner is likely to encounter. Interestingly, the authors note here that English law and London arbitration remain the preferred choice in the vast majority of ship sale and purchase deals. I think that's an important point to bear in mind, certainly something the International Bar Association would stress, and it's also something that's very much a selling point for successive British governments. So thank you for that point. The third and final section of the book deals with an intriguing range of financial issues relating to ship mortgages, actually ship mortgagees in this case, and various aspects of shipping finance, very complicated again, including using derivatives to finance ship sales and ship building. It's because of the immense costs, in blunt terms. Plus, there are 18 appendices which I've shown you, and a useful index at the back, and about 20 pages containing the tables of cases and statutes. Let me conclude by saying, to quote from the highly readable text, Having a ship constructed is not like ordering a new Ford Focus. That's where we came in. It is rather, quote, a highly cooperative long-term exercise between the buyer, the yard and others involved in the transaction. There are literally hundreds of such insights to be found in this book, which if you're a shipping lawyer, you'll find invaluable, and we certainly have found it so reading it. It's an interesting book, and it's a very important area of practice. The publication date initially seems to have been cited from the preface and the foreword as February 2015, but the book is actually appearing in 2016. But it's of a longer term importance. So I'd like to thank everybody involved very much for producing it. Here it is again. It's a heavy, as I say, a heavy book. You see it. It actually is quite important. It's hardback. There's the back of it. And then just going into the middle, you can see from what Lord Clark mentioned, you can see the very large number of footnotes that are there throughout. But you do have to have them. Remember, the secret, of course, with all of these books is read it straight through without looking at the footnotes, and that will give you a much better picture. You do get some very useful case law. For instance, there's a case here, Al-Kishtani and Shanshal, which is mentioned in some detail. Again, you've got a huge amount of detail and observation, which I think will assist for any very narrow points you might be looking at. And again, just looking, there are the author's biographies, well worth reading to see who they are. And of course, you do have some very substantial index, contents page rather at the front, and then the substantial index at the back. And just show that again. And then finally the index, which I do think is important, because if you're looking for something in particular, you should be able to find it in this index. Thank you very much anyway to the two authors, Baris Sawyer and Andrew Tettenborn, as the editors of the work, and all the people who've been involved. And I'd like to thank Informa Law very much with Routledge and the Taylor Francis Group for continuing to give us such excellent works to assist us with our practice. Thank you to all of you very much indeed. Bye-bye.